Welcome to the Newsmakers Podcast. I'm Billy Hollowell, and this is a show where we go behind the headlines every day to bring you an interview with a pastor, entertainer, politician, or other notable news figure. And this is a show, again, it's daily, but it's based on our weekly TV show, which is also called Newsmakers. You can watch it on the CBN News channel and also on our YouTube page. And on this show, every day, we dive deep. It's a little more longer form with one of the people who you will often see on our Newsmakers show or across the CBN News platforms. On today's Newsmakers, does Trump's massive $454 million penalty violate his Eighth Amendment rights? And what is the state of religious freedom in America? That and more on Newsmakers. We are welcoming to the show today Brad Jacob. He's a professor at Regent University who specializes in law. With no further ado, here is Brad to break it all down. There's been a lot of conversation, debate over these issues, these legal issues that former President Donald Trump has faced in New York, particularly the fact that over $400 million essentially he has been, or previously was, mandated to pay out. And there was some interest in that mix. It was a pretty large sum of money. And there have been lots of claims about what is going on there. Both sides have different perspectives on it. But one of the arguments that has come up is that the Eighth Amendment could be at play in some way, that perhaps this massive, some are calling it a fine, some aren't, this judgment that it is a violation of the Eighth Amendment. Before we even talk about that, can you describe the Eighth Amendment for us? Help us understand what exactly it's dealing with.
Absolutely. The Eighth Amendment says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And the Eighth Amendment is primarily about criminal law. In a criminal court, you can't give cruel and unusual punishments. You can't tar and feather someone. You can't impale them on a stake. Those kind of things are not permitted under the Constitution. Excessive bail, if someone is being held for trial on a criminal charge, bail can't be way out of proportion to the crime. If you're going to go on trial for jaywalking, they can't put $10,000 bail on that. Those kinds of issues. However, there have been some court cases saying that excessive fines could apply not only when it's a criminal fine, but also a fine or a judgment in a civil case. If the amount of money that's in the judgment is just way out of proportion to the offense that's found. And that's where you could at least argue that this might apply to Mr. Trump's situation.
Well, and then you have an appeals court, stepping in to knock that down quite a bit, right? 185, whatever it is, 175 million, it's come down. And so then that does sort of cause you to wonder, well, was it an overreach the first time? Of course, this is going to play out in the legal system, but it feels, I think, for a lot of people, regardless of where they stand on Trump, where they stand on the politics of what's going on with the election coming, that this seemed a little bit like something we haven't really seen before to this level. I mean, do you think that's sort of a fair assessment, or is that not a fair assessment?
It's certainly a reasonable argument to make. It was a very, very large fine. One side of that is if you're trying to deter behavior, then the size of a reasonable fine has something to do with the resources that a person has to pay the fine. And Mr. Trump is worth billions of dollars. So, hundreds of millions for him are not quite the same as what hundreds of millions would be for you or me or regular people. So that's one aspect of it, is it's sort of in context. It's particularly tricky in this case because it's hard to quantify the actual harm that he caused. Mr. Trump was found to have falsified his company's financial records, made it look like he was in a much better financial position than he was in. And so he got these loans and he got good interest rates. And the reality is, if he had not done that, maybe he wouldn't get the loans. Maybe he would have had to pay a higher interest rate if his credit rating didn't look as good. But he did, in fact, repay the loans. So at the end of the day, the people who were defrauded weren't really out anything out of pocket. There was just this opportunity cost that if the truth had been known, they probably would have made more money from him than they did. So trying to quantify that in damages is really difficult. It's not like someone took my car joyriding and destroyed it. Well, we can look at the blue book and know what the car is worth, and we can narrow in on a number. So here you're trying to put a number on a sort of amorphous loss. And then also, I think the court was trying to figure, how can we make this at a level that someone with all the wealth of Donald Trump will feel some sting, that it's actually gonna hurt him at some level, so he won't do it again. So you can defend the original judgment. I think what came out of the Court of Appeals is probably a lot more reasonable. But there certainly is at least an appearance here that Mr. Trump is being targeted. You haven't seen a lot of other cases where an offense like this one would have resulted in anything near this magnitude of a fine.
Well, even some of the debates that are going on around whether or not the values that they're claiming the properties have are accurate, that's a whole other thing. I mean, there's two sides on that, right? Are they undervalued? Are they overvalued? And $18 million from Mar-a-Lago, and you have so many facets of this. What is interesting, and maybe I'm overstating this, I don't know, but it seems like this is the type of case where you end up having precedent being set around something like the Eighth Amendment, because it's such a strange case that it would feel could drag out. I mean, who knows? Maybe it makes its way to the Supreme Court at some point. I mean, what's your take on it? Could you see a case like this setting new precedent around understandings of something like the Eighth Amendment?
Possibly, although, as I've said, there's already case law saying that a civil fine can be big enough to violate the Eighth Amendment. And so what you really got is not a law question, but a fact question. Is this judgment, this penalty, this fine so big that it reaches that standard? And maybe the Supreme Court would weigh in on that, but they might not. They might just say, well, this is within the range of what's reasonable, and so we'll let the lower court decide what a reasonable fine is under the circumstances. So they might take it, but they also might not. It might not ever go any farther.
Well, while I have you, I want to do a pivot into another issue, religious liberty. This is an issue you have worked on for a very long time. You're an expert in this arena, and we have seen over the last couple of years a lot of shifts and changes, a lot of very interesting legal battles from Joe Kennedy down the line. Joe Kennedy, of course, the coach praying on the 50-yard line, who had his victory at the Supreme Court. What is your take on the current standing of religious liberty in America based on everything we've seen the last couple of years?
Well, in religious liberty, we have two main constitutional provisions we look at. The Free Exercise Clause, saying that the government should not generally be prohibiting people from practicing their own faith, and the Establishment Clause, that the government should not establish a religion, establish a church, have a government-sanctioned religion. I would say in recent years, Establishment Clause law has been getting much, much better. We're seeing a huge improvement there. The court back in the 60s and 70s, in the years of the infamous Lemon versus Kurtzman, took this really hostile view towards religion in public life. And there was almost this sense that if you're going to be in a legislature, you're gonna be in public life in some way, you just have to put away all your faith and pretend you're a secular person, and only secular views are allowed in the arena of public life. Keep the religious stuff for church on Sunday morning. And the court, thank God, has moved away from that approach. And they're much more looking at the Establishment Clause as saying government should just be neutral about religion. It shouldn't be forcing people to be secular any more than it forces people to be Christian or Buddhist or Muslim or anything else. It should try to let people maintain their own beliefs unless they voluntarily change them. And we're seeing a lot of that in recent years. The Coach Kennedy case was certainly a good example of that where the fact that he is a coach and he takes a minute to kneel by himself and pray on a football field after a game doesn't turn that into government action and government coercing people to do something. So many better results there. Things like the Peace Cross in Maryland that was challenged because it was a World War I memorial to war dead in the shape of a great big tall cross, and the Supreme Court said no. That's fine. It's not an establishment of religion. Yes, the cross has a faith meaning, but it's also kind of a general symbol of honoring the dead. And nobody actually looks at that cross and thinks that the government is trying to force them to become Christians. So a lot better on those regards. Now, free exercise is a little trickier because in 1990, the Supreme Court basically cut the heart out of the free exercise clause, case called Employment Division versus Smith. They changed the test. It used to be from 1963 to 1990, you had a really high level of protection for free exercise. The government almost always had to accommodate your religious beliefs. If there's a law that would force me to violate my religion, I'm generally going to be exempted, even if other people have to follow the law. The 1990 decision changed all that and very much limited the ability to win free exercise claims. There haven't been very many free exercise claims won since 1990. But again, there's some indications that the court is pushing back on the Smith decision. That case was Antonin Scalia's baby. And now that he is no longer with us, I think the other conservatives on the court are feeling a little more freedom, Clarence Thomas and others, to say, yeah, that really isn't giving suitable protection for religious liberty. They haven't overruled it yet, but most recently in the Fulton versus Philadelphia, the case involving the foster care and Catholic social services in Philadelphia, we saw that there's a majority of justices who are ready to get rid of that Smith decision from 1990. So free exercise isn't as good today, but it looks like it's going to be getting better in the near future.
So I'm going to ask it might be a dreaded question. I don't know, I don't want to put you in a political position. This is more of an analytical one because it is interesting based on who obviously wins the presidency. You go back to 2016, had things been different, right? Regardless of, again, what people think about Trump, Clinton, anybody, we could be looking at potentially a very different situation right now. Could we not on some of these cases? I mean, let's say we would have had, Hillary Clinton for 2 terms. What might we be looking at on the religious liberty front right now when it came to cases like Joe Kennedy, let's say?
Oh, very, very different results. I think very clearly a court more hostile to religious liberty. I mean, in this country today, the political left is generally hostile to religious liberty, and the political right is generally sympathetic to religious liberty. It wasn't always that way. That Smith decision in 1990 was written by Antonin Scalia, and the liberal justices on the court at the time dissented. They wanted more liberty. They wanted more protection for individuals' rights to practice their own religious beliefs. But today it's become kind of caught up in this culture wars milieu, and it's gotten partisan like everything else has gotten partisan. So, if Hillary Clinton had won the 2016 presidential election, what does that mean? That means we don't have Neil Gorsuch, we don't have Brett Kavanaugh, we don't have Amy Coney Barrett. Instead, we've got 3 Clinton appointees, and then maybe still Ketanji Brown Jackson at the end. So you would be looking, instead of it, a court that leans more towards traditional values, leans more towards a textual understanding of the Constitution. You would be much more in the world of justices. I want to present it in a fair way. Justices who believe that the Constitution has to change with the times to be just and to respect human dignity and maybe rights and concerns that we wouldn't have thought of 200 years ago, what we sometimes call the living Constitution. That viewpoint would be dominating the court today. And I think Coach Kennedy would clearly have lost his case. And I think the Catholic Social Services in Philadelphia would have lost their case. And many, many of these recent cases would be coming down. Heaven only knows what they would have done with Jack Phillips out at Masterpiece Cake Shop. I mean, that seems to be the state sport in Colorado, is suing Jack Phillips, and he would probably have lost about 6 different lawsuits by now. So it would be very different indeed.
Well, I appreciate you taking the time to break it all down. Of course, these are complicated matters, and your insight is really helpful. Appreciate it. That's all for today's Newsmakers podcast. Be sure to tune in for the next episode of the show, and also head over to the CBN News YouTube channel and the CBN News channel to watch Newsmakers every week. We'll see you soon.